Welcome to the podcast for the Tuesday morning Q&A with Boyd W. Shepard D.D.S. J.D. Each Tuesday morning Q&A podcast is an edited and shortened version of the previously held live Q&A Zoom session. On Tuesday mornings each week, join attorney Boyd Shepard for a 1-hour Q&A call where you can ask Boyd questions. Then hear his detailed and knowledgeable responses to the legal concerns and business experiences of other dentists. For more information on how you can join in on the Q&A each Tuesday at 7 o'clock a.m., please go to legaldental.com.
Good morning, everyone. Happy Tuesday. Hope all is going well with everyone. We have a few joining us still coming in to the Tuesday morning Q&A, so we'll get started here in a moment. Thank you to all of you who have gotten up so early on another Tuesday morning to join in and participate and listen, and hopefully I contribute something that's helpful for you and we all share together. So here it is, December the 13th. We started in May, as most of y'all know, and here we are at the end of the year already. It seems like we started the Tuesday morning Q&A literally just yesterday. So it's really nice to have you on today, and the group has grown, and it's here in December. I'll mention it at the end, but my plan is to not have another Q&A until January the 10th. Taking off the 20th and of course the 27th, and I think it's the second or third. I guess it would be the third. So after today, we won't be logging on until the 10th of January so that people can focus on family and the holidays. It'll be exciting to get started again in January. I'm so used to the Tuesday morning, it's going to feel different to me. So but I so appreciate everyone who logs in regularly, and I certainly appreciate all of you who are new to the Tuesday morning Q&A. So today we're going to be talking about the 5 things that associates and applicants should ask employers. And the idea behind this came from, before retiring from the dental school, I worked as a professor in practice management as well as the law and regulations course. So it gave me an opportunity to work closely with students. But before that, I started that in, I can't even remember now, 2007 or so. And then retirement from the school was 2018, so 11 years. But prior to that, of course, I've always done work for employers and employees, dentists as owners of practices, as well as dentists wanting to go to work as an associate for a dental office or large multi-office operation. And that's one of the first, I think the first legal work that I did was for a classmate reviewing a commercial lease. That was the first job I worked on as an attorney licensed out of law school. The next one had to have been the review of an employment agreement. So I've been reviewing and discussing employment agreements and working with employers as well as employees, associates, owners on both sides of the agreement since that time, easily. And I was licensed in 1994, so it's been a while. I've seen a lot of agreements. As much as there are similarities in agreements, it's amazing to me the differences from agreement to agreement, depending on who the owner is. I've always said that an agreement just on its face can say a lot about an employer and what their philosophy, what the experience will be like just from reading the agreement. I've seen so many that invariably I get a sense for what that employment will look and feel like just based on the terms, the wording, the overall vibe, if you will. At first glance, it's completely unworkable. There's so many terms that are just overbearing or not reasonable. And a lot of times what that tells me, and again, it depends, but generally it tells me that the employer has an agreement, that they had perhaps an attorney or someone draft. Where agreements come from can take many different avenues. The employer may have hired someone like me or a law firm to draft it from scratch, and I do a lot of that work just from the beginning. And of course, I start with a template. I mean, I've seen so many agreements, but I try to get a sense of who my client is as an employer and draft an agreement based on what I hear and what I know what their needs are. They'll tell me, Boyd, I want this to be very straightforward and simple, or they'll say, Boyd, I really need this to cover a lot of ground. And I have a sense of that. So I'll have, on the associate side, I'll have young doctors who are just getting started or at any place in their career come to me and say, here's what I've been presented with by my potential employer. But as I started saying, even though the first draft, this may happen maybe 10 to 20% of the time, but it does happen, even though the first draft may be what I consider completely unworkable, there's just too many bullet points. There's too many items on the punch list that need to be negotiated. But I never really get a sense of this can never work. It really depends. And I would say the majority of those do work out. But if I'm being hired by the potential employee, the potential associate, I don't hold back. I don't tell them what they'd like to hear. They're coming to me to review the agreement and to determine whether or not this is not only a good contract, but generally whether or not is this a good deal? Is this a good relationship for me to even consider? And I go ahead and assist with that as well. And again, I would say easily 95 to 99% of the time, it's always going to be a good deal. It's always going to be a good relationship. It's rare that I get that situation where the terms are just so harsh, and particularly when the employer does not want to negotiate on certain terms that just are unworkable, that I tell the associate, look, you've got to be prepared to walk away from this agreement and keep searching. And I would say 100% of everyone I work with understands that, and they appreciate that. So anyway, just some perspective. There's so much to say about on the employer side, on the employee side. Today, we're going to cover the 5 things that associate side of all of these different questions. Of course, we're talking about the employer side as well. It's not just for the employee or associate to be thinking about these questions and these issues, but it is also for the employer to be thinking about and understanding their perspective of the question, as well as where the employee or associate is coming from on that same question. So even though the title weighs towards the associate or applicant, it certainly is for consideration on the employer side. Here we go with the 5 things that you need as the associate or applicant to ask of every employer. So the first item on the list there is location. Does the employer have more than one office location? Now, when you think about that particular question, that's a question that you should already know the answer to as an associate. You should know the answer to this before you even go on the interview, right? Before you go on an interview, I'm assuming that in today's world, you have already researched, you have gone online, you have explored everything there is to know about your potential employer before you go. You know, it's not like the 80s when I was a dentist associate looking for work and it was word of mouth. It was looking in the back of the Dental Society Journal for employment opportunities. It was not what you know, but who you know, referrals and different folks that I worked for to have had the benefit of the internet at that time as all of you have now. That's amazing. I mean, we can learn a lot about each other before we go to the interview in the first place. So something to think about as a potential employer. How does your office present? And obviously you've put a lot of time and effort into that already because you want your online presence to present well, just as a dental office, right? For your patients and your marketing. So know that employees are going to hopefully show up prepared in their interview and already know how many offices, how many locations you have. But why is that important? Why is it important to know on the legal side of things? Why is it important to know? And the reason is that in the agreement itself, the question will be for the associate, well, am I going to be assigned and working, and is my regular place of employment going to be in one office, or am I expected to split time at 2 or 3 different locations? And understanding that, if an associate is looking for work and they understand they're going to be splitting time between 2 locations, that's something to consider. What that really drills down to legally, though, is the non-compete, which we'll talk about later as one of the other questions to ask about. In the non-compete, if there's more than one location and the non-compete reads non-competition, covenant to not compete within 5 miles for a period of 2 years from the place of employment, well, which place of employment are we talking about? And if the 2 locations are several miles apart and you spent 50% of your time at one location and you split time and 50% of your time at the other location, well, arguably your non-compete of the 5 miles just grew larger beyond 5 miles of one center, but 5 miles of 2 different centers, which could look like a huge oval, right? And so that non-compete grew by default. How do you negotiate that? How do you negotiate the non-compete relative to 2 office locations? So that's something to think about as an associate, is if you're going to be splitting time. Now, I've given the example of 50-50 at 2 different locations. That's one issue. What if the answer is you are only expected to work at one location, but from time to time, you may be asked to work 1 day a month or 2 days a month at our second location. How do you handle the non-compete then? By default, because you did do some work and worked on patients and had time in this second location, does the non-compete extend to the second location? Everyone sees my point. So on the associate side of things, you want to be aware of the non-compete relative to your time in each location, if there's more than one, and how will the non-compete be interpreted relative to 2 different locations or more than one. It could be 3 different locations or more. The answer is make sure you get it in writing. Whatever you agreed to, and this is across the board, whatever the terms are, if there's anything that's negotiated that's not clear in the agreement, then you work it into the agreement as this is our understanding, not just a handshake, but in writing. So in writing, what does that look like? In writing, what that looks like is the non-compete shall only apply to the primary location, which is, and then list the specific address from which the non-compete will be calculated from. Or if it's going to be from 2 different locations and there's such a may have to get creative as far as how you word that. If it's going to be measured from both locations or more than one location, then again, all of this tracks back to the interviewee, the associate to be, the potential associate doing their homework on how many locations there are, everything that there is to know about the potential employer, and show up prepared in your interview to ask these types of questions. Again, let me welcome everyone who's joined us since we began. Thank you for joining. Today, we're talking about the 5 things you need as an associate or applicant to ask of every potential employer. Obviously, these issues are not just for potential associates, but also for employers, owners of practices to be aware of and thinking about when interviewing and taking on an associate. We've covered number one, which is location. And now for number two, compensation. Arguably, this is probably the first thing on a potential associate's mind is compensation. There is certainly, that's probably one of the top three issues to be prepared to ask about and work out. The question is, what is the offer for compensation and how is the pay structured? Don't be afraid to ask the question. At some point, the potential employer, the owner of the practice, should either volunteer this information as part of the interview or be prepared to answer what is being offered. I don't think the offer of compensation is going to be something that's not discussed. A lot of times what's not discussed out loud and what's presented in writing in the first draft of the potential agreement. And let me just back up a moment to say it's typically the owner of the practice that comes to the table and says, okay, this interview went really well. I like you. I will be sending you a proposed employment agreement. It's rare anymore that you would get a copy of that hard copy in person at the interview. It would be something that would be emailed to you either the same day or shortly after if the interview went well, right? And so that'll be the first time that you see the compensation offer in writing. It may have been discussed or not in the interview. And that's really my point, is that once the topic of compensation comes up, be prepared and have some sort of understanding while you have an audience, while you are there in person, while you're there face to face to discuss. Well, you might say, well, that compensation sounds really, really good. I'm very interested in that. Can you give me an idea before I get the agreement to look at how is the pay structured? Now, on the associate employee side of things, that's a great, what I call a tester question, in the sense of, can the owner of the practice, can the employer articulate, can they articulate how the pay is structured? Which is another way of saying, how straightforward is it? I hate to use the word simple, but how simple is the math? Is it straightforward or not? Is it a daily rate? Is it based on production? Is it based on collection? As far as a percentage goes, is it a combination? Can the employer, can the owner of the practice actually articulate as they sit there in the interview with you how their compensation offer is structured? And the reason I call that a tester question is because that would be a huge red flag to me as a potential associate, a potential associate or employee, of whether or not my future employer could even articulate what the compensation offer is. Now, I would argue that most will have no problem with. Again, you've got to remember, I've been reviewing agreements and discussing these issues with both owners as well as associates since 1994, and I've seen it all. And it's always a red flag to me when the employer cannot verbalize what the agreement is. The associates should be 100% confident that they fully understand all of the pay compensation calculation, which leads me to the point that I really want to make here. The compensation offer should be straightforward. It should be understandable. The math should be clear when written out in plain English. 3% of production or a base pay of X hundred or thousand per day, whichever is greater, period. Not difficult to understand, right? I can't tell you how many agreements, I literally cannot tell you how many agreements I've seen over the years that just find a way. I'm going to make try to be hilarious this morning. It's like, if you are a fan of the Houston Texans football team, right? Amazing how they find a way to lose the football game, right? Well, that's how I feel about this. It's amazing to me how employers, owners of practices just somehow find a way to convolute and muck up the language of the compensation to where you're trying to read it in writing. Not only is it not what was articulated in the interview, but when you go to read it in the agreement, I don't even understand what they're trying to do here. That's how I feel about it. It's something so straightforward. So how do you resolve that? Is that a deal breaker? Does that just blow the whole deal? No, not necessarily. It can usually be cleaned up very easily. And so that's where if the potential associate has hired me to do a review of an agreement, what I do is I go in, okay, I think this is, first of all, what was explained to you in the interview? Did they explain what the compensation is and what was your understanding? And we try to fit the language to what the interview discussion was, because that gives the associate a place to latch onto and say, well, when I go back to the employer and I present to them the changes that you want, that I'm negotiating how this should be articulated in the agreement, I can at least reference back to what was said in the interview if possible. And also grab what's going on and then decide what's going on in the actual text of the compensation offer in the agreement. What can be salvaged? What's the idea? What's the net result? What are we trying to get to? Can we simplify this? And that would be the next step. A red flag is when it's so convoluted and so not understandable, and then the potential employer does not want to negotiate how it is written in the agreement. That's a huge red flag. And I've seen that. I've seen convoluted explanations of compensation where, okay, well, let's go back and present this and let's try to simplify these terms, where you're just trying to get paid based on a percentage of collection or production, daily rate. It's really shouldn't be that complicated. And then the employer won't even negotiate on it for either reasons that they give you, or many times reasons that they don't tell you. They just don't want to negotiate. Huge red flag. So all of that to say, item number 2, 5 things as the applicant or associate that you need to be negotiating is, and asking questions about, is what is the offer of compensation and how is the pay structured? And let me say again, as I go along, if you have questions or things that you want to ask me about, feel free to chime in the chat, or turn off your or unmute yourself, I should say, and ask your question. Just totally interrupt me. That's perfectly fine. 3, scheduling. Many times the agreement does not discuss how patient scheduling for the associate is going to be handled. Now, I would argue and say that my understanding, based on conversations I've had with doctors over the years, is that patient scheduling is something that comes up and is discussed in the interview. They have an idea of what the employment is going to look like in real time, day to day, as far as days per week, hours per day. Is it Monday through Thursday? Is it 8 to 5? Is it Monday through Saturday? What's the scheduling structure for, what's the expectation of the employee? And that will at least be discussed verbally in the interview. But most dental contracts do not specify scheduling. There'll just be a generalized paragraph that says associate shall present themselves during days and times agreed to by the parties, period. Right. And it doesn't go into the details of that. I like it from the legal side of things. I like it when an agreement has been thought through to the point that the employer, the owner of the practice is articulating, this is what the expectation is on these particular days for these particular hours. Flexibility to be built in, which is as simple as unless agreed to by the parties, unless agreed otherwise by the parties. And the reason that that's important is you want flexibility. You want the associate to have an idea of this is how we're going to start. But on the other hand, give the associate the room to come to you or you to go to them and say, look, we need to switch this up a little bit now that we've been working a while. Let's agree to these days and these hours. Let's extend them. Let's shorten them. And again, depending on the situation, I'm giving you a broad sketch, actual relationship and the hours to be scheduled. My main point here is to articulate it in the agreement, but leave some room for flexibility. Another item to think about there is sometimes associate agreements will be very, very restrictive. In other words, scheduling is subject to, or scheduling changes, particularly time off, is subject to approval by the owner and employer. That requires some notice of 1 week, 2 weeks, a month, that if you're going to take personal time off, whether it be vacation or otherwise, that requires some sort of notice to the employer, and that can be fine and workable. But at the same time, I see a lot of times where there's language where it says, and only allowed if approved by employer, which is far too restrictive. I mean, you're both professionals and it needs to be more mutual, in my opinion. That's something to think about, is how flexible is the employer? You don't want to take advantage of the employer. You don't want to just, hey, I'm taking tomorrow off without notice, and you have patients scheduled and everybody has to now completely rework everything. That's not really reasonable on that side, on the employer side, to be given short notice, but at the same time, it shouldn't be so restrictive that the two sides can't be flexible as far as scheduling goes. So a lot of issues there to think about is, how is the patient scheduling handled? How can we mutually agree on scheduling? How flexible is the scheduling provisions? If anyone has a question, here's one in the chat. Would the associate scheduling include types of dentistry associate will be responsible for? Well, no, scheduling is scheduling days and times. The types of dentistry an associate's going to do, in my opinion, is going to be a completely different part of the agreement, a separate paragraph, a separate provision. It's a great question. Like I said, I know, for those of you who have logged on after I've said this, I actually have a form that's 70 questions to ask in an interview, right? So that would be one of the other questions to ask, is what type of dentistry is the associate expected or responsible for, if that's even an issue, if they're being hired to do a specific area of dentistry. I wouldn't necessarily put that in the scheduling. I'd have that as a separate paragraph altogether.
Dr. Shepard, can I ask you something?
Of course. Good morning.
Good morning. Okay, so what happened if the associate is as an employee or associate as an independent contractor? The timings can be set by who in that cases?
Thank you for asking that. So the question is, what's the difference between an independent contractor and an employee, and how does that relate to scheduling as far as who can set those hours? The difference between an employee and versus an independent contractor is going to be really a tax issue, a Texas Workforce Commission characterization of the employment issue, as well as a tax issue. Obviously, an employee, taxes are paid by the employer versus an independent contractor. The independent contractor is responsible for their own taxes on their compensation. So, and that's just the bare bones of it. And then we don't have time to go into it, but there's an entire area of the Texas Workforce Commission who tracks employment and how it should be characterized. And so for licensed professionals who get into these agreements, there is criteria that you can actually go you can go to the Texas Workforce Commission website and drill down to issues for employers. And one of the issues is my employee an independent contractor or an employee? How do I determine that? And there's a list of 10 or more different criteria for whether or not an employee is considered an employee or if they can truly be called an independent contractor. And the reason that becomes an issue is because you may present and sign off on a written employment agreement that is what you believe for an independent contractor for whatever reason. Let's say your CPA is saying, hey, let's make this an independent contractor. And you say, okay, and that's the type of agreement that you present and sign off on. And then here comes the Texas Workforce Commission and they analyze the situation. They're like, no, this is an employee because, and this gets down to your question, Dr. Cheda, one of the criteria is who determines the hours worked in the office, who makes the decisions on independent contractor working in the office. But again, there's 9 to 14 other criteria that they look at in combination: compensation, the equipment. I can't remember them all off the top of my head right now. The IRS, the federal government, actually has a shorter list of criteria to also determine and distinguish between independent contractor and employee. Scheduling, to Dr. Cheda's question, is one of those criteria. So no two are the same. It is something to consider. Hello, everyone. A quick break here in the middle. This is Boyd Shepard. I wanted to make sure that you know, if you are listening to this podcast, you can receive up to 8 hours of continuing education credit in risk management that satisfies the Texas State Board of Dental Examiners 8-hour biennial requirement. To receive this continuing education credit in risk management, please consider subscribing to the podcast for the Tuesday morning Q&A. Go to my website, legaldental.com, for more information. Thank you for listening. If you're going to be hiring as an independent contractor, if a owner or employer came to me and said, Boyd, we want to do an independent contractor agreement, what I do is I say, that's fine. I can draft that. There are certain issues that you need to be aware of as far as the IRS as well as the Workforce Commission. I direct them to where those resources are, and I recommend that they speak with their CPA because there are ramifications of getting it wrong, and you need to be aware of those. So thank you for that question, Dr. Cheda. Thank you to everyone who's joined us again. We're now up to the 4th issue to be discussed in an interview between an associate and an employer. Termination is a huge issue. How is the agreement to be terminated? I would say 100% of every agreement, or of the agreements that I've seen in my career, has a termination clause. Termination is always going to be something that's addressed in the agreement. Again, like compensation, it should be straightforward. It should be simple to understand. Either side may terminate upon X number of days notice in writing to the other side of termination. Where this gets a little difficult, I guess is the word I want to use, is when the contract is not clear about, hey, we understand we can give notice of termination X number of days, but when it actually comes down to termination, what's going to be the wrap-up process? Most contracts don't contemplate the wrapping up process. They just say, we want X number of days notice. Well, what's the X? The X is 30 days, 60 days, 90 days, 120 days. And that's a whole other discussion. I'll just say briefly that I've always said that the best termination period is 30 days, particularly for the associate, the employee, because if you are the one as the employee, the associate giving notice to terminate, there's usually a reason for that. It's you've found something better elsewhere, or you're moving, or it's just not working out where you are. It could be for positive reasons, it could be for negative reasons, but whatever the reason is, if you're the associate and you're ready to move on, then you're ready to move on. And so 30 days is ideal for you. On the employer side, the owner of the practice side, 30 days may be too quick. 30 days may not be enough time to, depending on the size and how busy the practice is, find someone to replace you, to fill that gap, to make sure all of the patients are taken care of, that there's a smooth handoff of treatment. If you're no longer going to be there for the continuity of treatment for, patients that are in temporaries or in the middle of a treatment plan, the employer owner is going to require more days notice to smooth out that transition to a new associate, or handling the scheduling of these patients so that it's not a rough bump in the road when you're no longer there to take those appointments. And that's totally reasonable and understandable. So negotiating the number of days for the notice of termination is a huge issue. 60 days, 90 days, 120 days. What I like to see and always recommend, but almost is never covered in an employment agreement, is what I'm calling the wrap-up process. Because invariably, whether it's 60 days notice, 90 days notice, 120 days notice, there's always going to be this carryover of patient treatment that somebody just didn't get taken care of, a treatment plan did not get wrapped up, a particular procedure was not finished, a crown, bridge, dentures, you name it, fill in the blank, was not delivered prior to the associate exiting the practice. And now somebody else has to do that delivery of fill in the blank, right? And so what I like to see is the two sides talk about that on the front, not on the back. And on the back's fine, but to get creative in where both sides work together and say, look, if there are patients that need to have work completed after the date of termination, and you can put this in writing, it's not difficult. After the date of termination, if there's work that needs to be completed, if there's items that need to be delivered, if there's patients that need to be seen that were patients of the associate, then the employer agrees to allow a former associate to come in on these following days or this number of days per week until all of these patients, all of their work has been completed. And I've seen that work so many times, and it's a win-win for everybody, particularly the patient, because they don't have to endure the transition to someone else that they weren't accustomed to and did not start the treatment with. It's certainly a win for the employee, former associate who's terminating, because they can control the outcome of that treatment. They're not relying on either the owner or a new associate to come in and complete the work that they started. Control the outcome in the sense that if things go south, and if a bridge doesn't seat, a crown doesn't seat, if there's something wrong with the denture, then there's continuity of care with a patient that the terminating employee and associate can work with and deal with, which actually is a win for the former employer and owner of the practice to reduce stress and headaches in dealing with a patient who may be unhappy because of their experience. You see my point? I mean, if you have a non-compete, it's not about worrying about the non-compete aspect. It's actually ensures the goodwill of the patient that there was such continuity of care that there were no blips on the radar for anybody, and working out a game plan to take care of that. That can actually be handled up front. There can be something agreed to in the initial contract that addresses, this is what we'll attempt to do. And again, have the language that says, unless agreed to otherwise by the parties, which gives you the flexibility to amend or supplement that idea when the termination actually happens. So something to think about there. Number 5, non-competition. Is there a restrictive covenant, and is it reasonable? So obviously, we talked about going back. We talked about 5 questions to ask. Location. How many locations does an employer have? Compensation, obviously being a big ticket item. Scheduling. What are the 2 sides, the employer and the employee, going to work out as far as scheduling? Termination. But obviously, the non-compete. Is there a restrictive covenant, and is it reasonable? And so with a restrictive covenant, it depends on a lot of factors. You know, the starting place for me with a restrictive covenant is, first of all, where is the practice located? Is the practice located inside the loop or inside Beltway 8 here in Houston, as an example? How populated is the area is what I'm getting down to. Is it inside the 610 loop? Is it inside Beltway 8? I would say any practice within Beltway 8, that circle, there's a large enough demographic that a non-compete that certainly is over 5 miles really needs to be negotiated. How far and for how long how far are patients coming to the practice that where you're working or potentially working, and for how long has that practice been in that location? If a doctor inside Beltway 8, the owner of the practice, is trying to push a 10-mile or more non-compete, then you need to negotiate that down. There are a lot of owners, believe it or not, that they're so confident in their practice. They've been in practice for so long. They're so confident in their patient base, they don't even require non-compete. And that's great for you as an employee. But if there is one, how reasonable is it? On the other hand, if you're working in a rural practice, and when I say rural, you know, what am I talking about? Am I talking about Hempstead, Texas? Am I talking about Navasota, where patients drive great distances? Then yeah, a 15-mile or more non-compete distance can totally be reasonable. It really comes down to the geographic location of that non-compete. And then that's going to relate directly to geographic location. It's going to relate to whether or not the practice actually, you know, where it draws from, but also what is the standard in that area. As an attorney, because I look at so many employment agreements, if somebody brought me an agreement and it's a practice that's in the Galleria area, but they wanted a 10-mile non-compete, first of all, I would say, well, that's unreasonable just based on the demographics alone. You negotiate it down, you negotiate it down. Well, I also know that working on agreements in that area or the surrounding area for so many different doctors, I know that the standard non-compete distance for that particular location might be 3 miles or 4 miles, that I won't let you stop negotiating that, or my recommendation will be don't stop negotiating that until you get down to 3 miles. Again, it depends. It depends on the demographics, depends on the number of years in practice, but it's important to have that in writing. And very, very quickly, there's the restrictive covenant as to mileage and number of years afterward. My recommendation on number of years 1 year should be enough, in my opinion. 2 years should be the max. So as a potential employer or associate, if it's anything beyond 2 years, then that's going to be, in my opinion, unreasonable. Non-compete covenants can be enforceable by courts of law. It will come down to whether or not the agreement was clear and whether or not the terms were reasonable. So there are a lot of issues that go into the legal enforceability of these covenants. And I will say while we're on here together that you also want to look at the enforceability and reasonableness of the non-solicitation. Non-solicitation is thou shalt not solicit former patients or former employees of where you are leaving from post-termination. But there may be an issue of, well, how do you define solicitation? Is it sending announcements to former patients? Is it doing a post on social media? Is that considered solicitation? And sometimes the answer, it's not so much about, well, I interpret it to not include social media, but how does the former owner and employer define it? And do I want to wait for a lawsuit to know how it's interpreted? That needs to be discussed up front, and perhaps even definitions inserted in the agreement that defines solicitation shall mean the following. That's huge. So I guess that goes hand in hand, because usually the non-compete and the non-solicitation go hand in hand with each other. Wow. I used up the entire hour, and we had some great questions, and which I really appreciate. Thank you to everyone who's on this morning. I am not in a hurry today. It's 3 minutes till the top of the hour. Many of you, if not all of you, may have patients scheduled or need to get going, which I understand, but I am not running you off.
Dr. Shepherd, this is just my observation. When the associates are working from different locations, this is just my observation that, they should work only on one location and get to know the patient properly, because a lot of times we get the patient from the different offices, and they say that, every time we go, we have a different doctors. And so they don't keep the continuity with the same associate. And even though sometimes they tells us, the associate who started my work, he was there, but then, today I saw someone else. So that's one of the things that I think it should be in the negotiation, that, keep the same patient to the same doctor, and preferably not moving from one location to the other location. That's just my observation from the patients.
Yes, thank you for that. That's what you're saying there is consider certain aspects of the relationship from the patient's perspective, right? What's in the best interest of the patient, and ultimately continuity of care, continuity of the provider. Certainly the winner in that scenario is going to be the patient, which should be the primary concern of both professionals. So I really appreciate that. Thank you for offering that. Yes, absolutely.
So, Boyd, a question I have is, I've heard that the patient belongs to the last treating doctor of record. So how does that work if you bring an associate on and you have the non-solicitation clause, but what trumps in that case?
Okay, so it's gonna sound like I'm picking on your words, but I'm not really picking on your words, because I hear this a lot. I'm picking on the words that I hear generally within the profession, which is what you're drawing off of. And the words that I'm picking on are the patient belongs to. And the answer is, and again, I'm not picking on you, I'm picking on this concept, okay? The concept is that the patients belong to, and that's a way of saying, it sounds like ownership. It sounds like, well, and really what you're talking about is ownership of the record versus, well, who does the patient belong to? And the patient belongs to themselves. the patient can always decide who their treating doctor is. But in this context, which is what you're asking me, and I'm getting there, is that in the context of employment, great employment agreements discuss this very issue, that when a employee, former associate moves on, that there's a paragraph that talks about the records and the patients shall remain with the practice. And when you agree to not compete and not solicit, that those are terms that say you're not going to do business and marketing that draws a patient away from their practice, that where they're an established practice. And so what that connects to is the state board rules and regulations legal analysis of that. And in the end, the state board legal analysis is we want what's best for the patient. We don't care as the state board from a legal perspective what you agree to legally. And we're going to respect that and let y'all fight that out as far as non-solicitation and non-competition. But in the end, we want what's best for the patient. We want to know where the records are, and we want to know that the patient is taken care of. And so when you talk about if an agreement says that you won't compete and you won't solicit, then that's a contractual obligation that if the employee associate signs off and says, okay, when I terminate, I promise for 2 years and for 5 miles, I won't compete. And during that time, then there's usually a separate time. It usually matches up the same. I also won't solicit patients and employees. Then that's a contractual agreement that has nothing to do with doctor-patient relationships. So this really gets to the answer to your question. That agreement should have some flexibility or some exception that says, however, if former patient, a former associate requires dental work to be completed, which is what I was getting at, that during that termination period or post-termination, if there's work that needs be completed, then the two sides work together to get that patient taken care of. That way, there's no question of the patient's established office location. It's just a question of wrapping up their treatment. And it's not a question of who does the patient belong to. Arguably, the patient belongs to the place they want to and choose to belong to. And what do I mean by that? Let's say the associate moves on, and they move on outside the non-compete of 5 or 6 miles, and they're at a new practice 7 miles, 10 miles, it could be 15 or 20, it doesn't matter. They're outside the covenant area. And let's say that I'm the patient and I'm like, well, I want to stay with that doctor. They were great. I don't care about the non-compete, and I'm not being solicited, and I know where that doctor went to. I'm going to go and follow that doctor. I, as the patient, have chosen to follow the doctor that's outside the covenant area, which I know nothing about. I don't know that there's a non-compete, and I don't care. I'm the patient. But the employer finds out that I left that practice and I follow the associate. Now, as the employer, my question is, well, did former associate solicit Boyd? Did they send Boyd something in the mail? Did they call him on the phone? Did they send him an email? How did Boyd know where they are? And the answer is, well, I'm the patient. I found out on my own. I asked you at your office, where did the associate go? And you told me. So the associate's not in breach of a non-solicitation. I don't belong to either one of you. I belong to who I choose to go to because I love one of you more than the other because one of you is just better for me. So I think that answers your question, is that there are issues relative to the state board requirements for records and who owns the records. And what that gets at is that in Rule 108.8, it talks about the records belong to the last treating doctor. Like they have to draw a line in the sand, but they also list out exceptions in Rule 108.8 for that. So that needs to be considered when you do an employment agreement. I hope I didn't convolute that too much.
No, that was great. Thank you.
You're welcome. Thank you for the question. Here's a question in the chat that's just to me. Can patients request info so they can follow an associate? Yeah, there's no restrictions on questions that patients can ask. I've seen that handled horribly by employers. I mean, think about that. If a patient asks the owner of a practice, hey, where did your associate go? They were awesome. I love them. They've been doing my treatment now for the last 2 years. I'd really like to see them again. Where are they now? And then the employer, owner of the practice, is not transparent and is not truthful about that because they are concerned about losing that one patient when they've clearly expressed the desire to go elsewhere. Trust me, that's not the way to go, to not be truthful about that. There's nothing in the law that restricts a patient from asking, where did a former associate go? And my recommendation to you as an owner, former employer, is tell them the truth, because they will find out. And when they find out that you weren't truthful, thank you to everyone who's hanging on. But I'm staying on to answer questions. And it can be about what we discussed this morning, employer, employee. It could be outside of that. If there's no more questions, we'll do a last call. But I do want to remind everyone, we'll be getting together again on January the 10th. We won't have any Q&As. I'll probably send out some emails in the meantime that direct you to other resources that are available through my office. But we won't meet again for the Q&A until January the 10th. Please email me your questions in the meantime, and we'll have several queued up, I hope, to start off the new year, and do invite your friends to join. Thank you to all of you who are here, and thank you for being with us since May of this year, and we look forward to 2023. With that, we're going to sign off. I hope you have an excellent week.
Thank you again for listening to the podcast for the Tuesday morning Q&A with attorney Boyd Shepherd. For more information on how to join the weekly Q&A each Tuesday morning at 7 a.m., go to legaldental.com.
This voice was produced in Typecast, an artificial intelligence voice service.